And then in paragraph 35, I've already mentioned that to you. Now, in paragraph 35 of the founding affidavit, as I understand the papers, the only reason that the Labour Party has come to the High Court is on its understanding that the High Court, as opposed to the Electoral Court, can finish an order expeditiously. Now, on the face of it, it seems to me that this is not a matter that should be before the High Court. And to the extent that the High Court, as I understood earlier, has got concurrent jurisdiction, what is the basis for that concurrent jurisdiction?
My lord, let me start off with the first point that you raised, which is to draw attention to paragraphs 27 and 35. So, paragraph 27, it is true that we say in paragraph 27 that the Electoral Court is the right. We didn't know anything. We didn't know whether it's, yeah.
In substance, the Labour Party are saying to the High Court that, in effect, the High Court should oblige the Commission to either make a decision or take some other conduct to do with the timeline.
No, so my lord,
on the face of it, I do not see how the High Court could make such a direction. So I would want to hear the basis to the concurrent jurisdiction which you intimated earlier.
All right. Let's start off at the very beginning. And the best place to do that is, I think there are two pieces of legislation that govern the proceedings in front of us today. The first one is the Electoral Act. And the Electoral Act, you don't have to turn to it yet, but the Electoral Act is Annexure FA3, and they've been attached unconventionally to the papers just to really be of assistance to you. I know we don't normally do this. FA3, you'll find the Electoral Act, and then the other one, of course, is the Electoral Commission Act, which is in FA2. The difference between that the elections are implemented and managed and conducted in a way that's free and fair. So those are the two pieces of legislation. Now, the Electoral Court is established under the ECA. That's where it is established, and you find it being dealt with in Chapter 5. And then, for example, a Human Rights Court. Now, what then if an aggrieved party lodges a complaint, they raise a dispute with the commission must give them a decision. Now that you've got a decision, what do you do with the decision? Well, you go, then we turn to Chapter 5 of this Act, where the Electoral Court has been set up. And Chapter 5, my Lord, to help you, is on page 37, case lines page. And the court is then established in terms of Section 18. Its composition is dealt with in 19. Its powers, duties, and functions are dealt with in 20. But look at that. Look at 20. The Electoral Court may review any decision of the Commission. That's what it's there for. It's there to review a decision. That's in sub 1. Sub 2, it can determine an appeal against a decision of the Commission. So there's an important jurisdictional fact here which confers upon the Electoral Court its power to do something, and that is the existence of a decision by the Commission. If the Commission hasn't made a decision, then you don't trigger the exclusive jurisdiction of the Electoral Court. Now,
but isn't the deadline the decision?
So no, it's not the decision. So I know that the Commission has come along and said, well, we've only made one decision ever. We made a decision to create and publish a timetable. And in that timetable, we've told you that you need to get your candidate lists in by the 8th of March. That's the only decision we've made. It's the only decision we have to make. It's the only decision we're ever going to make. And the question is whether they're right or wrong. Now, if they're right, then the point that we're debating now has some traction. But if they're wrong, then it's got no traction. And I will tell you that they are wrong. And the reason that they are wrong is a ground that I've already covered with you. And that is that they have to make a decision on a complaint that is lodged by somebody who's aggrieved. In other words, somebody has an electoral dispute. They must make a decision. Now, you can't come along here and say, well, what I did is I made a decision on the 24th of February. You complained about it in the beginning of March, but I've made my decision. The truth is you haven't, because your decision must be a decision in relation to the dispute or complaint that I've lodged. No decision has ever been made on that complaint. An original administrative decision, a timetable was made in February, but that's something completely different to adjudicating a dispute. And the adjudication of a dispute, which produces a decision, is ultimately what triggers the exclusive jurisdiction of the Electoral Court. Before that, it doesn't have exclusive jurisdiction. So that, in a nutshell, is the argument. Now, you can think about this, my Lord, in the most logical way. Think about, because what the election, let me go one step backwards. What we now hear from the Commission in its answering affidavit is it says, I don't have to make a decision. I've made it already. I don't have to reconsider anything. I don't have to even consider your complaint. I don't have to look at the dispute. I don't have to deal with the dispute. Well, it's wrong about that. It's wrong about that because Section 5.0, which I've taken you to already, tells us pertinently that its function is to adjudicate a dispute. Now, we've raised a dispute. They haven't adjudicated it. In fact, they've told us that they will not adjudicate it. And that's the problem. So it's a little bit like if you think about NEMA, if you think about environmental authorities in this country, they are obliged to make certain decisions, administrative decisions. So here the Commission made an administrative decision to create a timetable. Environmental authorities will make an administrative decision, for example, to grant an authorization. But Section 43 of NEMA is clear that if you don't like that decision, if you don't like the original administrative act, then what you must do is you must lodge a complaint, a grievance. There's an internal process. And you can't review something until you've exhausted that internal process.
Right. And forgive me, Mr. Bishop, I get the tenor of your submission. Now, now I will put questions to rather Mr. Hopkins. I'll put questions to Mr. Bishop shortly. Have you considered the decision of the Constitutional Court in the Liberal Party matter?
No, I don't believe I have.
Right. It's the Liberal Party against the Electoral Commission and others. 2004. It's in the law report as 2004, volume 8, BCLR 810 Constitutional Court. And there are a number of aspects which I would like to draw to your attention and to hear what your submissions are in relation to.
My Lord, can I quickly, it's behind me, the law report. Can I just get it?
Yes.
Thanks. So it's 2008, volume 10.
2008, volume 8. Well, sorry, what am I saying? 2004, volume 8, BCLR,
yep.
Page 810, that's the Constitutional Court.
Thank you, I've got it. Thank you, my Lord.
Right. Part of, well, the issue there you'll see recited in paragraph 18. What happened was that a list was published some 19 odd minutes, rather 21 minutes after the deadline. And so the list wasn't presented in accordance with the timetable, but the court made a number of remarks. And this seems to relate to my question as to whether the High Court is the appropriate forum. In paragraph 28, the court said that the timetable is published with the party National Liaison Committee, and that amending the timetable will disregard the consultative process leading to its publication. That's in paragraph 29.
Yes.
Now, the issue went to the Electoral Court. That was the first port of call by the Liberal Party in that matter, and it then went to the Constitutional Court. Yes. So that is part of my wishing to be addressed as to whether this type of an issue is a matter that could properly be considered by the High Court.
So my Lord, let's just be clear in our own minds what the High Court is being asked to consider. I accept that the Electoral Court is a specialist court dealing with specialist electoral matters, but you are not being called upon to deal with that. We need to.
Sorry, forgive me. That doesn't seem to be the case because in paragraph 12 of the founding affidavit, the Labour Party says the purpose of the application to secure an amendment of item 9 to the timetable. That's what they say.
So no, but hang on a minute. Newly formed political parties feel aggrieved by that timetable. None of them review the timetable.
Fired by the timetable, and now with reference to paragraph 12 of the founding affidavit, they say the purpose of the application is to secure an amendment of item 9 to the timetable.
So, my Lord.
So if that is the purpose of the application, how does the High Court have power to deal with this type of a complaint in relation to the conduct by the Commission?
So my Lord, there are two things. First of all, I was giving you the chronology, and with the greatest of respect, you took it over, which I don't mind. But when you took it over, you stopped short of completing the chronology, and you left out the relevant parts. The relevant part is that what then happens after the impugned timetable is published in the Government Gazette, a multi-party forum of 12 newly formed, well, they're not all newly formed, but 12 political parties get together and they lodge a complaint with the commission. Now, in the commission's answering affidavit, it says that they never got the letter of complaint. Now, I can't dispute that, but they say they didn't get it. But what I can dispute, well, not about what's being disputed, but I can tell you how that impacts on our decision not to go straight for a review, is because what happens is an article appears then in the Mail and Guardian, and you see this in Annexure FA7, and the Mail and Guardian reporter interviews people from the multi-party forum, and they explain exactly what the complaint is. They explain that the timetable is oppressive. They say it's unfair, it's unreasonable. They explain why. Then the reporter goes to the commission and says, what is your comment on their complaint? And let me read you what they say. At a briefing, this is not a media briefing that the commission give. I'm reading on page 121, the last sort of 10 lines of that page. At a briefing on Monday, the commission leadership dismissed the complaints, saying that the parties were well aware of the requirements of the process and that election date had been declared. The timetable was cast in stone, said the electoral body. In other words, we can't change it. We can't. It's an immovable thing. Then they say the commissioner, Nomsa Masuka, said, now this is her saying to the press conference, that the portal for signature has been open since 26 January. The parties have had quite some time to begin the process. Anyone who's preparing to contest the process should know that once an election date is proclaimed, the train starts moving. So, my lord, this is the important bit. The important bit is that after this, what do we think? Well, the Labour Party says in the founding affidavit what it thinks. It thinks that there's now a formal complaint, and then it thinks that the complaint has been dealt with under the dispute resolution mechanism in the Act. So it now thinks that the Commission is making a decision on the complaint. In other words, the electoral dispute. That's something that's going to trigger the jurisdiction of the Electoral Court. But then comes the City Press article at FA9. And the City Press article, now all of a sudden the Commission says something different. They say, I don't know what you're talking about. I've never heard of the multi-party forum complaint. Now, on the one hand, they tell us that that they know about it. They even comment on it, and then 3 days later, they say, I don't know what's going on. I don't know what you're talking about. I never received a complaint. Now, in light of this article, my client then says to itself, well, you know what? Whatever complaint newly formed parties had, they might have complained to the Commission, but the Commission is throwing its hands up in the air and saying, I'm not going to deal with this complaint. I've made a decision. I only have to make one decision. I've made it. I don't care whether you've got a complaint. I don't care whether there's a dispute. I will not deal with it. Contrary to what my mandate is in the Act, and I showed you that provision. Now the Commission says, I'm not going to do anything. So what does my client say? My client says, well, hang on a minute. I thought that it was being dealt with. Now I can see that it's not being dealt with, but I still don't know whether a decision has or hasn't been taken. So my client then files these papers and invites the Commission to make a decision, or to say, if you have made one, tell us what it is. 9 o'clock last night, we get papers which, with the greatest of respect to the Commission, don't help us much, because on the one hand, there's a paragraph in here where they say, I'm not going to make a decision.
Mr. Hopkins, just forgive me. Now, I understand when you submit about whether or not a decision has been taken, that will be, as I understand the case for the Labour Party, that will be a decision as to whether or not the date is going to change. So is that what the Labour Party understands to be the decision?
The Labour Party, yes, the dispute is that the timetable. So the complaint isn't the requirements in Section 27 of the Act. The complaint is we don't have enough time.
I understand that. So, and hence the question. With that, insofar as whether or not a decision has been taken, then the decision will be that the date remains as published,
Yes.
or we are going to change the date. Is that the case for the Labour Party in relation to?
Prior to that, that's why the papers are framed in such a way as there was no dispute, and we don't know what their decision is. At 9 o'clock last night, we found out from them that despite their mandate to adjudicate disputes, this is not one of those disputes that they're willing to adjudicate. And so now we've got a decision. Now I can go to the Electoral Court.
I was about to now deal with the issue that now, given how the Labour Party has formulated its course, you now have a decision.
Yes.
According to the Labour Party's understanding.
Yes.
And so, which means that this is now outside the remit of the High Court.
Well, not quite, because of this. The question is now that we have a decision, the question is, do we still need the interdict? So there is a case that I found called, my pronunciation may not be great, but I think it's Sikengu, an Electoral Court decision. And I could just tell you that the summary of the head note provides that the Electoral Court does not have the jurisdiction to grant an interdict relating to a matter that falls outside the provision of Section 20 of the ECA. Section 20 of the ECA, I read it to you earlier. It's the provision that says the court has got the power to review or to appeal a decision that's been made. So outside of that requirement, it doesn't have the power to grant an interdict. So I'm coming to you for that interdict. And why do I need it? That's the question, because the commission say you don't really need an interdict, because if you now take your review to the Electoral Court, they've got wide remedial powers and they can give you exactly what you want. In other words, they'll listen to your complaint, and if they think that you changed on the timetable because you weren't given enough time, don't worry, they can reopen the portal for you. That's how I understand their papers. And we
forgive me, the Electoral Court is obliged to deal with matters referred to it expeditiously.
Yes.
So now that the Labour Party have a decision,
yes.
There is nothing that stops the Labour Party to approaching the Electoral Court to deal with the issue expeditiously.
There is absolutely nothing that stops us from approaching them with an expeditious review. The question, though, is whether or not the Commission is correct that the Electoral Court has the remedial power to reopen the portal later on, after it's already closed. Do they have the power to reopen it? Now, and this really is, my lord, because I would never, ever in my life stand in front of you and argue nonsense. There is only one issue in this case, and that's this issue. This issue is...
let's deal with the reopening of the portal.
Yes, that's the issue.
Because that was dealt with by the Constitutional Court in the Liberal Party matter. Have regard to paragraph 27 of that judgment. The court dealt with the reopening of the portal, which was, and the court said that the Commission can change the timetable in respect of Section 20,
yes.
And then qualified that by saying, if it is necessary for a free and fair election.
Yes.
So that will be a rider. And then in paragraphs 28 and 29,
yes.
The Constitutional Court had regard to deal with the nature of the timetable, etc., and the role and participation by the Party National Liaison Committee.
Yes.
So, but certainly, I do not understand it to be the case that the High Court could order the Commission to reopen the portal.
No, the portal is open. The portal is open. You don't have to reopen it. What the High Court is being asked to do is to effectively grant a restitutionary interdict to keep the portal open for another week or so that people have got enough time to do what they need to do. That's all that they're asking for. It's not a big thing. You know, it seems like this big technical argument and whole lots of technical reasons why we can't do it. My Lord, with the greatest of respect to the Commission, we have an election coming up. Political parties are getting disqualified and falling by the wayside because they can't comply with onerous requirements. And all that we ask this court to do, in the interests of democracy, in the interests of a free and fair election, is to keep that portal open for another week. That's all. Just another week.
It seems to me that that would be, and I would hear from the Commission, it seems to me that that would be a request to be made of the Electoral Court.
Well, let me tell you why it isn't. It isn't a request to be made of the Electoral Court, because what the Commission tells us, it refers us to a judgment, which I'm going to, I'll just tell you where it is in their papers. Michael, feel free to chime in if you get there before me, but it's the Electoral Commission versus the Copter Minister. I'm just trying to find that reference, my Lord.
What is the substance of the decision?
The substance of the decision, according to the Commission, is don't worry. Take your review to the Electoral Court. The Electoral Court will listen to you, and if the Electoral Court thinks that you weren't given enough time, it will reopen the portal later on. And the substance of their submission is it has the power to do that. Now, my Lord, here is why I say there's only really one issue, and why I wouldn't want to waste your time with others. The real issue here is, does the Electoral Court have the power to reopen the portal, or doesn't it? If it does have the power to reopen the portal, then I absolutely agree with my learned friend. And that is that if they have the power to reopen the portal, we don't need this interdict.
But
if they don't, yeah.
No, but the Constitutional Court has answered the question. To answer the question directly, it says it does have the power. I draw your attention to again, paragraph 27, where the Constitutional Court said that the Commission can change the timetable in respect of.
Then I've got every reason to ask you for the interdict, and I'm going to make my submission to you now that they are wrong. The Electoral Court does not have that power. Now, why don't they have? Yeah.
Forgive me. So the court has no power to order the Commission to reopen the portal. Is that a submission?
The Electoral Court, yes.
Yes.
Yes. Now in order for me to explain that argument to you, I need to take you to the my Lord, I'm so sorry, but I haven't been able to find that reference in my own notes. Sorry, in the affidavit.
No, it does happen. It's somewhere.
I've got it.
In the very last paper that you would look at.
It is. It's paragraph 34 of the answering affidavit.
Yes, read it to me.
Okay. So this is now the commission, the commissioner speaking, and he says, a similar situation arose with respect to the 2021 local government election. A date was set for the election, and the Commission adopted an election timetable. But the Commission also approached the Constitutional Court to postpone the election beyond the constitutionally permitted timetable because of the COVID-19 pandemic. The Constitutional Court refused to do so. And then he goes on to say, the Commission in paragraph 35, indeed, the court set aside the proclamation of the election to allow voters to register. It also empowered the Commission to make other amendments to the election timetable. And then here comes the important bit, 6 lines down. It did so even though the timetable had not been set aside and the original date for candidate nominations had passed. Now, I respectfully disagree with the Commissioner's assessment of that case. And I know that my learned friend acted for the DA in that matter, so he knows the case better than I do, and he will tell me if I'm wrong. But what I understand is the following. So these are the notes that I've made. So you'll forgive me for taking you slowly through it. Remember, my lord, in the back of your mind the whole time, why am I taking you through this case? To show you that it is not the Electoral Court who has the power to reopen the portal. That is not what this case stands as authority for, and nor is it analogous to that particular proposition. So what happens is the following in this case. Hang on a quick moment. All right. So what we've got is the municipal elections. Now, my lord, as you know, when an election is proclaimed, on the date that it is proclaimed, various things happen. Relevant to our case and the case that the commissioner referred us to in the Concord, relevant to that is an obligation is triggered straight away on the commission to establish a timetable. So in the case of our national election on the 29th of May, the president says we're having an election on the 29th of May 2024, and the commission then says, well, I better jump into action, and I need to draw up a timetable that tells everybody by when things must be done. That's really what that's all about. The same thing happens in the case of municipal elections, which is the case this case here that the commissioner referred us to. There, it's not the president. This time, it's the COGT minister. What she does is she says we're going to have municipal elections on a particular day. In this case, I think she said 27 October 2021. She said we're having elections, and she proclaimed that date on the 3rd of August. So the commission says, gee, I don't have much time. I've got 85 days. Let me draw up a timetable of what needs to be done. But what happened in this case, which is absolutely unconventional and unusual, and the Concord says so, Justice Rogers makes the point clearly when he says it is no ordinary case. Why is it no ordinary case? Well, because there was a COVID-19 pandemic. Now, what was the problem here? The problem is that you've got a municipal election coming up on the 27th of October, and the Electoral Commission has drawn up a timetable. In its timetable somewhere, it says there needs to be a voter registration day. Now, my lord, you'll appreciate a voter registration day. It might not, you and I may not need it because we were registered to vote a long time ago. But if you're a new voter, you want that day so that you can go and register your vote. Normally, it's held at a sports center or somewhere. So around the corner at the local sports club, you can go and register there for the municipal elections. And if you don't register, you can't vote. So it's really important that you can register. And some of the political parties said, well, that's why you need a voters registration day, because if you don't have that day, then new voters can't register and they're excluded from the election. Well, and it was the commission in that case that approached the Electoral Court 8 times trying to postpone the election. Eventually what happens is the COGTA minister, despite the fact that we're in a COVID-19 pandemic, the COGTA minister says there will be an election. The commission then say, well, here's the timetable. But the commission were about to launch litigation, as far as I understand, in which they were going to apply to the Concord to postpone the election. And the reason for that is because they said it won't be free and fair. It won't be free and fair because we can't have a voter registration day. And why can't we have a voter registration day? Because the COVID-19 regulations said that more than 100 people can't gather at a time in the same place.
All right, Mr. Hopkins, I understand part of the chronology. What is the substance of what you seek to comment to the court? Because the context here, as I understood, has got to do, they're now, because you are now, or you should now be seeking to persuade me that the High Court, given that now there's a decision, can still grant an interdict. That is where the events have come to now.
Yes. So, right. and you remember I started by saying, if I can persuade you that the Electoral Court doesn't have the power to reopen the portal, then I must get the interdict. But if the Electoral Court does have the power to reopen the portal, then I accept that I shouldn't get the interdict. Comes down to that crisp question. So now I can tell you why it is. In relation to this matter, what eventually happens is the Constitutional Court says we cannot postpone the election. But first of all, it says that the Cogta minister's decision is unconstitutional to proclaim an election.
Sorry, Mr. Hopkins, because we are relating the details which seem not quite relevant to here. There will be a point of principle in that case, and which is what I would like to hear.
Okay, the point of principle.
Which aspect to that decision supports your contentions?
The point of principle is that in that case, it is the Constitutional Court who found that the proclamation of the date was unconstitutional, and that triggered the broad, just and equitable remedial discretion of the Constitutional Court to grant any order that it wants to grant, any order that it deems is just and equitable. So once that jurisdiction was triggered, and it had to be triggered by unconstitutional conduct on the part of the Cogta minister, then the Con Court said, we are free now to make any award that we want to. And I'll tell you what our decision is. Our decision number one is that the election will go ahead, even though it's been unlawfully proclaimed. And the Commission, you will do your best to try and have a voter registration day. If you can. If you can't, well, too bad. But if you can, you must do it.
Forgive me. What is the unconstitutionality in this matter, such that this might be proximal to that decision?
There isn't any. That's why it's not proximal. We're not in the Constitutional Court. We're not triggering Section 172 here.
And then I do not understand why you are referring the court to an authority that it appears doesn't quite deal with what this court has been asked.
My lord, let me just take you through it slowly, but you must let me please just run through this train of thought, because the train of thought starts off like this. The Electoral Court is a creature of statute. It gets its powers from the four corners of the legislation that created it. It doesn't have inherent jurisdiction to do what the Constitutional Court can do. So the Constitutional Court may have been entitled to do something fancy in the municipal election matter, but the Electoral Court can't do that fancy stuff here. And if the Electoral Court... Yes?
Forgive me. The Electoral Court has got powers in law, in review proceedings, and powers in law in appeal proceedings.
Yes.
And on the face of it, I do not see how, in exercising its review jurisdiction, the Electoral Court cannot make a determination regarding the timeline as that court exercising its review powers, which will entail everything that the law allows a tribunal such as that to order.
My lord, if that is the case, your ruling would have to be that you believe that the Electoral Court can make an order to reopen the portal. You would have to make that finding. And to do that, you would have to find a power somewhere in the Electoral Act which gives the court that power, and you won't find it. And that's the problem. If it's there, it's there. But if it's not there, it's not there. Can you imply it in there? I don't think you can imply it in there. And the reason I don't think you can imply it in there is because the Commission themselves tell us, first of all, they didn't go to the Electoral Court. They went to the Constitutional Court. So can we go to the Electoral Court and hope to get the same kind of relief that the Constitutional Court might give? I don't think so. I don't think that this court, which is a creature of statute, has those wide remedial discretionary powers that the Con Court has. And the Con Court only had it because it first found that there was it first made an order of unconstitutionality, and that allowed it to do something that was just and equitable. Here, no order of unconstitutionality is being sought.
Yes. Now, I understand now the substance of your submission to be the following, that the Electoral Court has no power to order the Commission to reopen the portal.
Yes.
That's the case.
Yes. Yes. And if that is the case, then of course we can review. Of course we can review the unreasonableness of the timetable. And there might well be things that the Commission can do, but I don't think it can order the reopening of the portal. And if I'm wrong, as I say, well, then I'm wrong.
And you submit that it will not, in law, have that power exercising its review jurisdiction?
Yes. Yes, because it's a review jurisdiction, but I'm not entirely sure where the remedial power pursuant to the review comes from. So we can review conduct and we can find that it was unlawful. What do we do then? Normally we set it aside, but can you go one step further and order remedial relief akin to an interdict? In other words, a mandatory interdict saying, and now you will go back and you will open that portal for a long time. But I can give you another reason why we need this relief from you. And that is because when you read the Commission's answering affidavit, they tell us in no uncertain terms that the portal shouldn't be reopened. They tell us in no uncertain terms that the timeline, the timetable shouldn't be fiddled with because of what they call the cascading effect. In other words, if you fiddle with one timeline.
That's something else.
Yes.
The Commission saying that the timetable should not be fiddled with, that's got nothing to do with whether or not in law the Electoral Court has the power which we were debating earlier.
You are right about that.
Those are two distinct issues.
Well, they are related in this sense.
No, they can't be related. They can't be related in that the view which the Commission takes, it would be a view that the Commission takes. But as a matter of law, the Commission might be correct, or they could be mistaken. But the Electoral Court can't be bound only because the Commission has expressed the view that it doesn't want to amend the timetable. If the law permits the Electoral Court to issue certain directions, well, they will have that power, and the Commission will have to fall in line.
Well, so there are two things. Remember, you might have the power to review something, but the remedy following a review. So the review is really just the process in terms of which you find that something is lawful or unlawful. That's what a review is. Once you find it's unlawful, you don't have to set aside the decision. You don't have to grant remedial relief. You don't have to do any of those things. In fact, there are times when courts have reviewed unlawful administrative action and not given any remedy. They haven't even set it aside. We know about those cases like JF Sapela, and so that happened. Now, in a case like this, what makes a court decide whether, consequent upon an unlawful finding, it should remedially do anything? Well, it's down to practical stuff. And in this case, the Commission says it's impractical to fiddle with the timetable. And that's how you connect the impracticality of the relief with the purpose behind the review. So with respect, my lord, hopefully I have persuaded you that there's some kind of a connection between the two, and that it doesn't matter. It doesn't matter that you can do something if you've already told us that you won't do it.
Yes, I'm just making notes.
So, my lord, in light of everything from where we are now, where have we come to in this debate?
I'm just getting to that part, Mr. Hopkins. That's actually what I'm making my notes on. And it me that this has crystallized to one issue.
Yes.
And that might be the basis for what decision that this court makes. Just bear with me. It seems to me, Mr. Hopkins, that in the light of you and the court, that this is where we are, that there's at this point just one issue, which is this: whether the Electoral Court may order the Commission to reopen the portal in the exercise of the Electoral Court's powers, review powers in relation to decisions by the Commission.
Yes.
Right. And
yes.
And the case for the Labour Party is that the Electoral Court does not have that power. And because it does not have that power, the Labour Party is before the High Court seeking an interdict. That
yes.
Right.
Yes, my lord. And yes, that is exactly right. And all that we're doing is we're not asking for anything drastic, because we know that what will be drastic is to change the timetable. We're not asking for that now, because remember, the nature of the case that we conceived it changed at 9 o'clock last night. Now what we're asking you to do is to keep the portal open for another week while we have our review. That's all. Nothing that drastic. It's not going to mess up the timetable in any way. In fact, I can show you that under the timetable itself, there is provision made for the portal to be reopened later. All they need to do is to keep it open now for a week on the basis that it closed too quickly. People didn't have time to do what they had to do, and let's give them a little bit of time to do that.
Yes, thank you, Mr. Hopkins. The exchange has been most helpful. I'll hear from Mr. Bishop. Mr. Bishop, you've heard the exchange between the court and Mr. Hopkins. It seems to the court that the matter has come to the following aspect, i.e. whether the Electoral Court may order the Commission to reopen the portal in the exercise of the court's review powers in relation to decisions by the Commission.
Yes.
That's where we are.
Yes, my lord, I'm happy to address that issue first. And I think that issue has a very, very clear and simple answer in favor of the Commission. So let me deal with that first, but obviously without giving up any of the other arguments that the Commission intends to make. So the power isn't in the Electoral Commission Act, it's in the Constitution. Section 172(1)(b) of the Constitution, which I'm sure your lordship is familiar with, says that when deciding a constitutional matter within its power, a court may make any order that is just and equitable. And that applies to the Electoral Court, and the authority for that proposition is the decision in Electoral Commission of South Africa versus Speaker of the Umhlutuzi Local Council. The citation is 2022 ZAEC 11, or it's also reported in 2023 Volume 1, All SA Law Reports 386. And at paragraph 70 of that judgment, Zandi J.A., who is joined by unanimous bench, holds and applies the court's just and equitable remedial power under section 172(1)(b) of the Constitution. He says, as regards the remedy, section 172(1)(b) of the Constitution provides that upon a declaration of constitutional invalidity, a court may make any order that is just and equitable. And then it goes on to deal with the other cases that say that power is even wider. It can be a remedy not prayed for, and that the remedy not prayed for can be granted even in the absence of a finding of invalidity. And this court will, of course, be aware that in the ordinary course, in administrative review proceedings, whether under the Constitution or under PAJA, that if a court reviews and sets aside a decision, it has the power in appropriate cases to substitute that decision with a decision of the courts. And that's part of the just and equitable power it has either under Section 8 of PAJA or Section 172(1)(b) of the Constitution. So with respect, there's absolutely no doubt at all that the Electoral Court has the power, if a review is brought and the review of the election timetable is successful, to order the Commission to reopen the portal for an appropriate period. So, my lord, I think that there are many other reasons to dismiss the application in addition to that one, but I don't want to take up this court's time unnecessarily, because as I understood my learned friend, Mr. Hopkins, he conceded that if the answer to this question was that the Electoral Court can grant such an order, that his client must go to the Electoral Court, and that this court should grant no order, and that it should dismiss the application. I think that the one important point that I would like to make, my lord, is about when there was a decision, because that this might go to questions of costs.
I see.
Because what Mr. Hopkins argued was that the Commission only took a decision, or only informed his client of the decision at 9 o'clock last night. But of course, that's not the case, my lord, for two reasons. The first is that the decision was taken when the election timetable was published. that is the decision. That's really what the Labour Party's concern is. It's paragraph 9 of the timetable, which sets the date of today to file your candidate nominations. That is what they want suspended. And the decision to set that date was taken on the 24th of February. So that is the decision of the Commission. The Labour Party seeks to get around that in two ways. Firstly, it seeks to rely on the approach by other parties, not by it, by various other parties who allegedly wrote a letter to the Commission asking for it to change the date.
Forgive me, Mr. Bishop.
Yes.
I think your submission as to what the decision is doesn't accord with the case presented on behalf of the Labour Party, because I understood Mr. Hopkins to submit to the court that the decision, as far as the Labour Party are concerned, was to know whether or not today's date was fixed, and that they only found out last night that the date is fixed.
Yes.
And from their universe frame of reference, that is a decision that they contend for.
Yes.
And now they do have a decision. The question being what is to happen, which was the substance of my exchanges with Mr. Hopkins.
Yes, yes, and I don't want to complicate the matter unnecessarily, my Lord, because I think even if Mr. Hopkins is right, that the decision only came in the Commission's answering affidavit on his own submissions to your Lordship, they must go to the Electoral Court, because he accepted that if the Electoral Court has the power to grant the just and equitable remedy, his client has no business in this court. So I don't want to unnecessarily complicate it, but I think it is an important point, because the Labour Party could, on the 25th of February, have challenged the election timetable. There was no need for there to be an additional decision not to amend. It was free to go immediately to the Electoral Court once the timetable was published. But what did the Labour Party do? It did absolutely nothing. Nothing. It didn't write to the Commission. It didn't lodge a dispute with the Commission. It didn't ask the Commission what it had done with the letter supposedly sent by other parties. It did nothing until Wednesday when it launched this application. So, Lord, it might be a different case if the Labour Party had come a day or two after the timetable and sent a proper complaint to the Electoral Commission under Section 510 and said, we wish to lodge a dispute with you. The time you've set in paragraph 9 is unreasonable, will not lead to free and fair elections, and we are requesting that you reconsider it. Maybe that would be a different case, but that is not this case. This case is a case where the Labour Party did nothing at all and then came to this court and tried to manufacture a new decision by saying, we don't know what the outcome is, so we're waiting for the Commission to tell us. But with respect, they did know what the outcome was, because it's clear from the articles that they attached to their own papers what the Commission's position was. My learned friend took you to the article that was in the Mail and Guardian published on, I want to get the date correct, it was sometime in late February, I think a day or two after, I think the day after the letter had been sent by the other parties, where the Commission says there will be no change. But then more importantly, on page 128 of the papers, so this is the article that's published in City Press on the 3rd of March. At the top of page 128, it says, the IEC said it has no record of such a meeting request. So they knew then that the Commission hadn't even received this letter. It hadn't received the letter. And the Chief Electoral Officer says under oath that the Commission did not receive this letter. So it's unclear how the Commission was possibly supposed to take some fresh decision, having just published the election timetable, to reconsider one of the dates in that election timetable, where literally nobody had written to it to ask it to do so. And certainly Mr. Hopkins' client had not done so.
Yes. So those would be considerations, according to the Commission, which the court is to bear in relation to costs.
Yes, because what the Labour Party should have done and can still do is go to challenge the election timetable. It's late now, but it can ask for condonation from the Electoral Court to say, yes, we're out of time, but we want condonation to challenge the election timetable. But what it can't do is manufacture its own timetable, because the Electoral Court rules are clear. It says you must come within 3 days. And the reason for that is because elections happen quickly and decisions have to be taken quickly. I've appeared in the Electoral Court several times, and that court moves very swiftly. It moves very quickly once an application is before it, for good reason. And what the Labour Party is trying to do here is say, well, yes, you published the timetable, but we can at any point come and ask you, no, please change the timetable, and then force you to say yes or no. And then we have another 3 days that starts running from that date to go to the Electoral Court. With respect, that would defeat the purpose. The Commission cannot be expected to reconfirm what it has already decided every time a party asks it to change the timetable.
Yes. Do you have any further submissions?
No, my lord. So just on costs, for that reason, because this application should never have been before this court, and also because of the timing with which it was launched, my lord, it's in the affidavit. I don't intend to take your lordship through it in any detail, but this case was launched on Wednesday. The Commission was given 1 day to answer it and was in court the next day when this timetable was set more than, I think it was about more than 2 weeks ago. So it's completely unreasonable. If it wasn't dismissed for lack of jurisdiction, it should be struck from the roll for self-created urgency. And because they can get all the remedy they need in the Electoral Court through a just and equitable remedy following a successful review, if they are successful. So it was an abusive application, and the Electoral Commission should be entitled to its costs. This isn't a case where they came to court properly and only discovered in the answering affidavit that they didn't have a case. They should have known from the outset that it was inappropriate to come to this court, seeking the relief they did and at the time that they did.
Right, thank you.
Yes. Thank you, Lord.
Thank you. Mr. Hopkins?
Thank you, my lord. My lord, so just two very, very short points. Mr. Bishop's submission, and I really do appreciate that he hasn't given up the other arguments, and that they're still in his papers and you may still have regard to them. But really his concluding submission to you now was, he said there are 2 reasons why this application should be dismissed. And I'm not sure if the first is actually a reason why it should be struck from the roll, and the second one is why it should be dismissed. He said, number 1, you've come late. The Labour Party's come late. And he says, number 2, you can get all the remedy that you want from the Electoral Court. So my only replies to those 2 points. And whether we've come late or not, you've seen the facts that are on the affidavit. And it seems to me as though the question is whether what we did is reasonable. In other words, was it reasonable for the Labour Party to have believed what it read in the Mail and Guardian? Mr. Bishop says, why didn't we phone and ask? Well, why should we doubt it? The spokesperson for the IEC has been quoted. So surely we're entitled to believe what the IEC says via its spokesperson. Why must we write them a letter and say, hang on a minute, was the spokesperson telling the truth, yes or no? Oh, why must we do that? This is a public authority, somebody who's supposed to be believed and can be believed. So if we want to know something we're not sure, we're entitled to look at the news statements, the press releases, and the media interviews that its spokesperson gives. So I don't think it's unreasonable. And if it's not unreasonable, then I can't see that we should be mulcted with the costs of this application. So I think on that leg, if we're talking about costs, the question really is, was it or wasn't it reasonable for us to believe what we read in the media statements? There was a second sort of perhaps more subtle aspect to Mr. Bishop's argument in that score. And he said, well, you didn't lodge a complaint yourself. You can't rely on somebody else's complaint. But why can't you? I mean, doesn't that happen all the time? That somebody challenges a constitutional decision or any decision, And when they do so, they challenge it on behalf of everybody. It's either objectively right or objectively wrong, and it affects everybody. You can't expect everybody who's affected by that decision to have to complain about it. Surely it's enough for one person, or in this case 12, to complain, and it either is or it isn't a valid complaint. And we're entitled to wait for the outcome of the complaint. And we did wait for the outcome, and then we got a conflicting media statement, and then we said, well, you know what, we'll bring our own application. And that's what happened. I don't think that's unreasonable. And my submission to you is that you hopefully won't find it unreasonable either. So that's the first of Mr. Bishop's 2 points. The second one, so remember the first one is, well, you came late, and the second one is, don't worry, you'll get all the remedy that you need from the Electoral Court. I gave you my submissions as to why I didn't believe that it had this wide remedial power. Mr. Bishop's response to you was to give you a judgment that was delivered by Zondi J, where Zondi J said that unquestionably, the Electoral Court can apply a just and equitable remedy. And he says that puts the matter to bed. And he says that it comes from section 172 of the Constitution. I just want to look at 172 of the Constitution. We know it. It's the remedy that follows a finding of unconstitutional conduct. You first got to find the unconstitutional conduct. Now, I don't know whether the unconstitutional conduct would be the same thing as unlawful conduct. I think when you're exercising a public power, like a body like the Commission might do, or the Electoral Court, you might be inclined to say, well, the exercise of every public power is a constitutional issue. But not every exercising of public power by a public body triggers a constitutional infringement. Now, I don't know whether there's a constitutional infringement in relation to producing a timetable that operates unfairly or unreasonable in relation to some newly registered political parties or unrepresented political parties. And if that's the case, then it's not about a finding of we haven't launched the review. We haven't asked for a finding that there's unconstitutional conduct. You can only trigger this wide remedial discretion if you find that something unconstitutional has happened. That's not what we say. That's why we ask you. Just keep the portal open. Keep it open for a week. Let us have our review. Let us have our review. When we get to the Electoral Court, we'll ask them for relief. You don't have to, my Lord, with the greatest of respect, and I say this coming back to the very first thing you said in this hearing. And what you said was, not what you said, I suppose you had concerns about whether or not we're in the right forum. You know, can you really get involved in matters that belong to a specialist court? And you had genuine concerns, and I can understand them, and I can sympathize with their concerns. Those concerns are valid if we are asking you to do something like amend the timetable, which I appreciate is what's being asked for in the notice of motion. But I think that two things happened. I think that number one, the answer has forced us to revisit that, and number two, I think that these proceedings are flexible enough for us to ask for alternative relief if that relief isn't appropriate. I don't think that relief is, in retrospect, perhaps the right relief. I think the better relief is simply to say, let's have a restitutionary interdict that keeps the portal open a little bit. It's open now. It closes at 5 o'clock today. And I'm just saying to you, don't let this thing close at 5 o'clock today, because people are still battling to upload thousands and thousands and thousands of sheets of paper. Please don't let it close today. Just keep it open a bit longer. You're not extending, you're not fiddling with the timetable. You are not, well, I suppose you are indirectly, but what you're not doing is you're not bogging down the election in a way that's going to frustrate the process and have a cascading impact on other aspects of the timetable. You're just keeping the portal open for a little bit longer while we lodge our review, and then we're in the hands of the Electoral Court, where we should be. Those are my submissions, my Lord.
Yes, thank you. Gentlemen, thank you very much. Mr. Bishop?
I apologize, my Lord. I neglected when I was addressing you to give you a reference to two cases on this question of the jurisdiction of the Electoral Court and the High Court.
Yes.
If I may just give them to you briefly. The first is a case in the Supreme Court of Appeal called Mketsu, M-K-E-T-S-U, versus the African National Congress. and the citation is 2003, Volume 2, Essay 1. And in that case, the court held that the High Court did not have jurisdiction to deal with a particular type of dispute, which is a dispute following an objection following the declaration of results, that's an exclusive jurisdiction of the Electoral Court because it goes to the heart of electoral matters. The other decision, my lord, is a decision of the Constitutional Court, which is KHAM, K-H-A-M, versus the
K-A-M.
Yes,
Right.
versus the Electoral Commission. And the citation is 2016, Volume 2, SA 338 CC. And the relevant paragraph is paragraph 40, which says that the clear purpose was to establish a court that would be able to deal with all electoral matters. It was constituted with the same status as the High Court and with the judge of the Supreme Court of Appeal as its chairperson. It is to resolve electoral disputes as a matter of urgency. There is not the slightest indication that the intention was to limit the range of disputes that would fall within the ambit of the Electoral Court's jurisdiction, so that some electoral issues would fall within its jurisdiction and others not. So it says all electoral matters are within the jurisdiction of the Electoral Court. That it doesn't say that the High Court does not have jurisdiction, but it emphasizes the wide breadth of the Electoral Court's jurisdiction in the electoral matters. Sorry, Lord, I meant to refer those
Yes.
to those matters. I omitted to do so.
Thank you. Gentlemen, I thank you again. I'm mindful of the time is of the essence. The court is going to reflect on your submissions. I see it's just past 1:15. The court will reconvene at 20 to 2.
Thank you, my lord.
Thank you. Will
As
rise.
the court, please.
Order, gents.
Thank you.
Thank you, Judge.